So, the Nintendo and Pokemon vs. Pocketpair patent lawsuit has now gotten a few more details, although they are still a little bit vague and a little bit nebulous, a little bit more alleged, shall we say, so take everything with a pinch of salt as always. First and foremost, Palworld has responded saying, regarding the lawsuit, yesterday a lawsuit was filed against our company for patent infringement, so this confirms that yes, it is actually real. We have received notice of this lawsuit and will begin the appropriate legal proceedings and investigations into the claims of patent infringement. At this moment, we are unaware of the specific patents we are accused of infringing upon, and we have not been notified of such details. This is unusual, but I'm presuming again that Nintendo and Pokemon are basically playing a somewhat naughty game here, and this is further reinforced by some of the alleged patents that they have infringed. So one of them that popped up on Twitter is this one here. In an example of a game program, a ground boarding target object or an air boarding target object is selected by a selection operation, and a player character is caused to board the selected boarding target object. If the player character aboard the air boarding target object moves towards the ground, the player character is automatically changed to the state where the player character is aboard the ground boarding target object and brought into the state where the player character can move on the ground. That is a lot of patentese to say that Nintendo has patented a mount system, in essence. And that when the mount, if airborne, once it hits the ground, will transform into a ground walking form, like a bird walking on its feet instead of just, continuing to fly. That appears to have been what they have patented here, and patented, I want to point out as well. So, type application filed May the 2nd, publication date August 29th. So that appears to have actually passed, since this is the publication date, which is usually when you issue it after you've actually received it. Though, again, Japanese patent system, so pinch of salt and all that, as we'll get into the peculiarities of that system a little bit later on. But notice here, filed May the 2nd, 2024. So this patent was filed after the launch of Palworld, and presumably also accepted after the launch of Palworld on August 29th. That sounds an awful lot like Nintendo specifically went out of their way to create a patent to then target Pocketpair with. There's another one. In a first mode, an aiming direction in a virtual space is determined based on a second operation input, and a player character is caused to launch in the aiming direction an item that affects a field character disposed on a field in the virtual space based on a third operation input. In a second mode, the aiming direction is determined based on the second operation input, and the player character is caused to launch in the aiming direction a fighting character that fights based on the third operation input. Or in short, they've patented throwing things and throwing Pokemon, presumably, into an arena to fight. Again, filed May the 2nd, publication date August 22nd. Yet again, after the release of Palworld. Now, these aren't the only ones. There are also some that have been created first. Like this one, for example, is filed September 30th of 2019. Now, this one, I believe this is playing a sound. Basically, what this whole muss have done is that it plays a sound when you capture a Pokemon. So you capture the Pokemon and it goes da-da-da-da-da, a specific noise. That's what this in essence is. So they have added in things that aren't actually new, shall we say, and here it also says date of patent, you may see, rather than publication date. So type application, whereas type grant. So there is the possibility as well that these haven't actually been granted yet, mind you. It's depending upon the exact wording and the meaning here. Now, when it comes to patenting things in games, there are a surprising amount of things you can actually patent. For example, you might recognize this thing. This is the dialogue wheel from Mass Effect. It is patented. Now, specifically, the form is patented, and also things like I think it was always the good guy option is at top, always the negative option is at bottom, and so on. This is a patent. It is legally protected. You may remember there was a fairly large controversy a while ago around that whole Lord of the Rings game, which name I now don't recall actually, which had the Nemesis system. Now, I never played this series for myself because it looked cool, but I was like, I never really got around to it. Well, that Nemesis system is actually also a patent-protected system, where you develop, a nemesis over the course of a gameplay career. This is also why we have never seen any system like it, despite the fact that, of course, this game series was very, very popular. And this was not only the only thing that game series was infamous for either, as it was also one of the first instances of PC game reviewers, or reviewers in general, being essentially given a briefing document that they had to sign to be allowed to get access to the early access version of the game, which basically outlined that you weren't allowed to show bugs, for example, in the game. That kind of like spun it as if they were expecting the reviewers to give it a good review in return for a early access code, which, of course, these days is more of an accepted and implied thing rather than a firmly written thing. And this also kind of falls into a little bit with what I would have thought that Pokemon would have sued Pocketpair with, which is copyright, as we have another example. This is quite old. Pac-Man versus Casey Munchkin. So this was a rather important one back in the day, where the courts decided that Atari, I think was the developer, it can copyright things like, for example, the Muncher, or the Power Pills, or the Ghost, and their general appearance. However, Atari was also claiming that the company was infringing on them in terms of the wider gameplay, and the court also ruled that no, you cannot claim to own things like broad concepts. You cannot claim that you own the idea of being chased through a labyrinth, for example, which is basically what Pac-Man is. However, you can claim that you own being chased through a labyrinth as a specific figure being chased by specific enemies. That was fine. So, again, complications. This was also determined here that, of course, the reasonable observer, which I mentioned in the last episode, one of the reasons why the court came down on the side of the Atari was because they looked at the game's graphic and said that a reasonable observer could confuse Casey Munchkin with Pac-Man. They could look at a ghost next to another ghost and go like, yeah, I don't see the difference there. I think they might be from the same game. They could look at Pac-Man, or Gobbler as it's called here, and go, again, I think this might be the same game. There were enough similarities to the point where a layman who had no real understanding of either game might confuse them. This is also why, again, the copyright angle would have seemed a far more reasonable one to go after Pocketpair for, because I maintain my position. A layman is going to look at this picture and think, well, clearly that's from the same setting, right? Though, this then adds in a lot of other things as well, as, of course, Palworld is far from the only game that does this, as you've also got games like Digimon, for example, which borrows heavily and both theories are making rather similar looking characters, and this would actually be an in-court defense. Pocketpair could easily look at a patent like this for, boarding things or throwing things and go, hold on, that's a really broad concept you've got there, sir. Why haven't you sued anybody else for this? Which would be a good argument for the copyright claims as well. They could bring up a picture of Charizard, Charmander, the little red dragon thingy, and the other little dragon thingy from Digimon, the one that's the pet of the spiky-haired dude. It's been a while since I watched Digimon, okay? And they can go, okay, these characters look very similar according to the standards that you've laid out here. Why have you not sued them? Is there some kind of double standard here? Is this a malicious lawsuit, which... yeah, it probably is. This is in all your likelihood, again, just the shotgun approach, where Nintendo loads up everything they can, and Pokemon, and fires it at Pocketpair in the hope of overwhelming them. Now, this, of course, is also Japanese law, which is why, well, a lot of our previous examples are actually kind of pointless, because they're American, of course. But Japanese patent law is a bit weird. So originally, I went looking for the actual document of Japanese patent law. I had to give up because I couldn't find an official English translation. Why? Because one doesn't actually exist. An official English language translation of the law does not exist. So the only thing that exists is an unofficial translation. In other words, you cannot rely on it being correct. That's Japan for you right there. Oh, yes, indeed. Now, I can understand Nipponese, but I cannot read moon runes because it is an objectively inferior goddamn lettering system, and I refuse to learn it. But some of these things on Wikipedia will be a good enough guide. So, to get a patent, you need, for example, novelty, innovative steps, or industrial applicability. So, novelty is that it's something that hasn't really been done before. Something unique. Now, these patents would not probably fulfill that, I would imagine. Inventive step is that you have figured out how to make something in a way that nobody else can really necessarily replicate, shall we say. When at the time, the application, a person ordinarily skilled in the field of art to which the invention belongs would have been able to easily make the invention based on technology falling under any of the items blah blah blah. The invention can be patented. For this decision to be made in the abstract, an accurate assessment is firstly to be made to the standard of the art in the field of art to which the invention belongs. So in other words, if a layman can make it, or not even a layman, a person ordinarily skilled in the field could make it, then it cannot be patented. So something remarkable, shall we say. But then there is industrial applicability, and there is, of course, absolutely industrial applicability in creating game mechanics like mounting something or throwing something. So, if anything, I'd presume they'd be leaning on this one, though again, it is a little bit nebulous whether or not these patents have actually been granted, or if they are in the process of being granted, but at the same time, it would be weird to be able to sue somebody for a patent that hasn't actually been granted yet. It's a bit of a confusing case there, and it's probably not going to get any less confusing unless people who actually know Japanese law in specific begin weighing in on it. So, yeah, it is absolutely looking like a rather churlish lawsuit, and the fact that they haven't actually informed the Palworld developers of exactly what they're being sued for speaks to this yet again. More and more, it really feels like Nintendo and Pokemon are just kind of scattershotting things here to see if any of it will actually stick. And they've got more than enough money to spend on this, so they don't really care, and they assume that Pocketpair doesn't. As they also mentioned in the tweet here, this will of course take, time and effort away from actually making the game. This is, if we are to be a little bit mean to Nintendo, a way for them to maliciously interfere with the development of what they apparently believe to be a competitor or an alternative to their own product. So, if we assume malice, yeah, this is probably a rather strategic lawsuit that Nintendo and Pokemon might not actually give two shits if they actually lose or not. They are merely trying to see what happens. And additionally as well, Nintendo and Pokemon doesn't have to win all of this. They don't have to demonstrate that the entirety of Palworld is a ripoff of anything that they've made. They only need to prove one thing. As mentioned in the Atari thing, one of the things the judges said there, that it does not matter how much of your game you argue is original. If there is still something that infringes upon the opposing side's property right or intellectual property right, etc., then it is still in violation. So Palworld's going to have to beat all of the allegations, and Nintendo is only going to need to get one of them passed. It's a mean move, and no doubt about it. Malicious outright, one would quite happily argue, particularly judging by the filing dates here. And additionally, just in case you were wondering, okay, why couldn't Pocketpair file for this? They could actually have filed for this as well, assuming the broad nature of this. However, Japan is a first to file nation when it comes to things like patents. So when Nintendo has already searched for that patent, okay, we're going to claim this, Pocketpair can then not come later and say, hold on, but we can claim this because this is, again, patent, not copyright or trademark, which will be created whenever you make it. In theory, if you come up with a thing, you come up with a completely new alien, for example, you technically already own the trademark and the copyright for that, as long as you can prove that you were the one who came up with it. And if somebody then, in 6 months' time thereafter, goes, oh no, I made that, it's still yours. But in case of patents, it's whoever actually gets it on the books first, which is, again, probably why they did this. Until more news and details come out, however, it is all still purely speculatory, and again, even the examples I can dig off from American courts is, in essence, completely and utterly worthless. Though the good news is that, of course, patents are not international. You can apply for an international patent, but you need to do it and get it granted in the various nations. So even if Nintendo gets this through, that will not actually mean that they can sue, any company with these patents. They would first have to actually make one in the country or within the trading bloc that recognizes it and then go after them. So for the moment, this is solely a problem for Japanese corporations. And that is about all we have for now. Until next time, I have been Arch. Thank you all very much for watching. And as always, of course, I will add in the disclaimer that I am not an expert on these matters. I am a layman at best, so I'm going to give you my point of view as I see it with my limited understanding. And I hope to see you all again soon, despite it. Have a good day.